and their collective judgment must be respected. Now, as I'm sure you know, Mr. McEnroe, I have no discretion in this matter. The jury's verdict mandates a sentence of life imprisonment without the possibility of release or parole on each of the 6 counts to be served consecutively. On the other hand, had all 12 jurors agreed that the state had met its burden of proof, this court would now be imposing a sentence of death, likewise as required by law. The fact that 2/3 of the jurors concluded that execution was the appropriate punishment should be a sobering thought that stays with you for the rest of your life. You have been afforded a tremendous opportunity, Mr. McEnroe. It's the opportunity to live out your life to its natural end. This is an opportunity that you denied to each one of your victims, including 2 children who had barely begun their life's adventure. You've been afforded this opportunity despite the fathomless anguish that you caused the victim's family and friends. You've been afforded this opportunity despite the harm your actions have inflicted upon countless others who have been touched by this case, including the jurors who were handed the unenviable task of deciding your fate. You've been afforded this opportunity because you live in a society governed by the rule of law, not by anger, vengeance, or vigilantism. The process has been long and arduous for everyone involved. For some, it may have seemed like this day would never arrive, but it has. Although your life has been spared, Mr. McEnroe, this court now sentences you to the harshest sentence otherwise available under the law. Life imprisonment without the possibility of release or parole on count 1 for the murder of Wayne Anderson. Life imprisonment without the possibility of release or parole on count 2 for the murder of Judy Anderson. Life imprisonment without the possibility of release or parole on count 3 for the murder of Scott Anderson. Life imprisonment without the possibility of release or parole on count 4 for the murder of Erica Anderson. Life imprisonment without the possibility of release or parole on count 5 for the murder of Olivia Anderson. And life imprisonment without the possibility of release or parole on count 6 for the murder of Nathan Anderson. With regard to fees and costs, the court will impose the mandatory victims assessment penalty, the DNA fee, waive all other non-mandatory fees and assessments pursuant to State versus Blazina, and a restitution will be set by the court within the statutory framework. Mr. O'Toole, have I left anything out, sir?
You know, the only issue I might raise is there was testimony, I think, in the course of the trial that Mr. McEnroe had some assets in the neighborhood of, I thought it was $10,000 or $12,000 or $15,000. I don't know if that factored into your determination with respect to the payment of court costs and fees.
It did, counsel, but I think that would be best directed towards restitution, which I do believe would be imposed.
Thank you.
So thank you, sir. Anything else, Mr. O'Toole?
No, Your Honor, let me get this moment finished.
Okay. And counsel, I know we discussed this earlier, but would Mr. McEnroe waive his presence at the restitution hearing if what needs to be said?
Yes, Your Honor.
And you've discussed that with him?
Yes, Your Honor.
Thank you, Mr. Fresco.
The defendant's total legal financial obligation is $600 independent and exclusive of restitution. If any, I will provide a copy of the court rules to counsel regarding the payment of that obligation.
Thank you.
There's also a community custody provision with respect to serious violent offenses in the event that Mr. McEnroe is ever released, and there is a theoretical possibility, of course, that he would someday be granted clemency or pardon. That is on page 5 of the judgment and sentence. It provides for a crime committed within the time range of Mr. McEnroe's crimes, a community custody term of 24 to 36.
I will impose that with the understanding that it's unlikely to ever be effectuated.
with respect to the payment of legal financial obligations, I don't know if the court wanted to indicate at this time, or maybe wait until the restitution hearing, what the schedule might be. Obviously, the defendant will not have a community corrections officer if all goes as we live will.
Mr. Presti, do you want to weigh in on that? It may be best to wait to determine the magnitude of the restitution amount.
Certainly, Your Honor. That's what I think is best.
Okay, so we will reserve on that, Mr. O'Toole.
And I don't know if you mentioned this, Your Honor. I apologize if you did. I missed it. With respect to the weapons enhancements, I'm assuming you're posting judgment on those as well.
Certainly, thank you.
Does the court have any indication in its records of credit time, sir?
I do not.
Have you put as calculated by the jail?
Yeah, we'll have it calculated by the jail. I know it's significant, but I don't know what the number is.
And the state was requesting, I can't remember if it's in our paperwork or not, that the court receive a no contact order between the defendant and any member of the victim's immediate or extended family.
I would certainly grant that.
No objection.
Before we recess, I would ask all of you to join me in a moment of silence in remembrance of Wayne, Judy, Scott, Erica, Olivia, and Nathan. Thank you all. Court is in recess.
All rise. Close the room.